Hello, today I will be presenting a legal case study on British Airways Data Breach of 2018, one of the most significant cybersecurity and privacy case that comes under GDPR. That's the General Data Protection Regulation. Commonly, it is known as GDPR. While many people remember this event as a cyber attack, the legal significance of case goes far beyond the technical breach itself. The case becomes a landmark for example for organizations about how they should be held responsible when they fail to protect users' information. Throughout this presentation, I will analyze incidents, discuss the laws applied, examine the stakeholder responsibility, and evaluate ethical implications, and explain how this case influenced cybersecurity governance and privacy regulation. So the purpose of this case study is not simply to explain how attack happened. Instead, I'll focus on other key areas as well. I will analyze the legal framework that was applied during the investigation. I will evaluate how GDPR was interpreted and enforced by regulators. I'll also examine ethical responsibilities of British Airways and other stakeholders. Finally, we'll also discuss the broader impact this case had on cybersecurity governance, public trust, and not just this one, but future practices. So let's see briefly about the case background. British Airways is one of the largest airline companies in the world and it processes millions of online transactions every year. To provide these services, the organization collects and stores large amount of user data like name, addresses, their travel details, email addresses, and most importantly, they also store the payment card information. So under GDPR, British Airways is classified as a data controller. This means the company is responsible for deciding how personal data is collected and processed, and it also carries legal responsibility for protecting that information. Because of the sensitive nature of data, the strong security controls were expected. Let's see the technical overview of breach, how the breach occurred. So, the breach occurred between August and September of 2018. Attackers associated with the Macecart cybercrime group inserted malicious JavaScript code in British Airways online payment page. So, when customers entered the payment information, the code was secretly copying the data and transmitting it to a fake website domain that was baos.com. So what makes this attack more interesting is that customers remained on the genuine British Airways website throughout entire process. There was no fake login page, phishing email, or obvious warning sign. It makes it more difficult for a common user or a non-technical person to even realize that the site is compromised. So as a result, approximately 429,000 customers lost their personal and financial information they were exposed during the time. So if we go with the legal timeline, the attack begins on August 2018 when for the first time the malicious code was inserted in the payment system. In this early September, British Airways identified suspicious activity and they quickly removed the malicious code. And as soon as they did that, they also publicly disclosed the breach and notified the customers and regulators. The ICO then launched a formal investigation in July of 2019. So ICO announced that it is going to impose the fine of 183.39 million pound to GDPR. So after considering mitigating factors and other things or reviews by the British Airways, it reduced the fine to 20 million in October 2020. So although it is reduced, it remains one of the largest GDPR penalties imposed at the time. So the jurisdiction this case falls on primarily is UK itself. The main regulatory body responsible for this was Information Commissioner Office ICO, and the uh, main regulation was GDPR, the legal framework which was applied, and it recently came into effect across the Europe in 2018. So the case also attracted attention from European Data Protection Board EDPB because it represented one of the first major GDPR enforcement actions. So let's go through the laws that were applied in the case. So it applied Article 5 and Article 32 of GDPR. So Article 5 establishes the principle of integrity and confidentiality, meaning organizations must protect personal information from unauthorized access and misuse. And Article 32 requires organizations to implement appropriate technical and organizational security measures based on level of risks that are involved. The ICO concluded that British Airways has failed to implement adequate safeguards and therefore they breached these obligations. This finding in some way formed a legal foundation of how the case moved forward. So the legal arguments that were made were strong on the both sides. So one of the most critical aspect is how they argued the case. So ICO argued that British Airlines failed to implement sufficient security controls despite processing highly sensitive consumer information. So according to them, strong monitoring, security testing, and access control could have reduced the likelihood and even the impact of the breach. On the other side, British Airways argued that it was the victim of sophisticated cyber attack and highlighted its cooperation with investigators. So, however, ICO ultimately determined that being victim of cyber attack does not mean that organization is no more responsible for the security of consumer data. So they were responsible to implement appropriate security measures. So this interpretation became one of the main outcome of the case. So if we talk about the stakeholders, customers were the primary victims because their personal and financial information was exposed. Secondly, the British Airways was responsible for protecting consumer data and ensuring compliance with GDPR, them being the data controller. And other stakeholder is the attacker as well, the Maze Card, cybercrime group. The ICO was the regulator responsible for investigating the incident and enforcing privacy law. And one of the noticeable stakeholder was financial institutions. They were affected because stolen payment information increases increased the fraud risk and generated additional cost. So if we look at the ethical analysis from deontology perspective, ethics is based on duties and obligations. So customer trusted British Airways with highly sensitive personal and financial information. So British Airways is morally obligated to protect the information regardless of the cost and resources it might have to invest in this. Although the attackers were responsible for the crime, the organization still had to see the risk and try to prevent it. From this perspective, the breach can be viewed as a failure to uphold an important duty of care. So, on the other hand, utilitarianism evaluates actions according to their consequence. The breach exposed hundreds of thousands of individuals to financial risk and reduced public trust in digital services, not only the British Airways. Although stronger cybersecurity controls may have required additional investment, the harm caused by this is way higher than the investment that could have been required. From this perspective, investing heavily on cybersecurity would have produced better outcome for customers, organization, and overall digital society, I would say. Also, the societal impact were huge. So it was beyond just British Airways. It was about the whole digital services ecosystem. Many individuals become increasingly concerned about how organizations collect and protect personal information. The incident also raised awareness regarding privacy rights and data protection obligation. More importantly, the case reinforced the idea that consumers have a right to expect organizations to safeguard the information appropriately. So, as a result, public expectations regarding cybersecurity and privacy continue to uh, go ahead, and yeah, the case was in the favor of public at the end. So there were several impact on cybersecurity governance as well. One of the most significant outcome of this case was uh, the organization's perspective change. Now, the cybersecurity issue was not just IT issue. Now it goes beyond the technical part, and it is a governance issues that involves executive legal teams, accounting, compliance officers, and board of directors. The British Airways case demonstrated that poor cybersecurity can create legal, financial, and reputational damages to the company. So it makes it a strategic business concern rather than a simply technical problem. One of the interesting fact I came across while researching the topic is the attackers used a deceptive domain that was called baos.com to receive stolen customer information. Years later, a domain was acquired by a cybersecurity company called Seaside, and they transported it into a education resource. That would explain how breach occurred. What was once used to facilitate cybercrime is now being used to educate organizations and all the stakeholders about preventing similar incident in the future. So, based on the lessons learned from this case, organizations should adopt a proactive approach to cybersecurity governance. This includes conducting regular security audits, continuous monitoring, like far-sighted thinking. They should avoid the employees, and this there should be proper incident response plan in place. Finally, I would like to conclude by saying cybersecurity failure is governance failure. The British Airways breach was far more than technical cybersecurity incident. It became a biggest dent in GDPR enforcement case that established important principles regarding accountability, privacy protection, and organizational responsibility. The key lesson from this case is that cybersecurity should not be viewed solely as a technical issue. It should be analyzed as legal, ethical, and governance level challenge that requires leadership, accountability, and ongoing commitment. Thank you. And these are the references for the report. That's